We got a brand new order from Judge Canon, and based on it, if Merrick Garland, the Attorney General, would just hurry up, we will get Volume 1 of Special Counsel Jack Smith's final report, 500 pages, 1,000 pages about the D.C. election interference case, the one we really want to read about. We'll get it by midnight tonight. If he doesn't act quick enough, I don't know what's going to happen with the 11th Circuit and the Supreme Court and Donald Trump. I'll catch you up. You're here on Legal AF, the YouTube channel. Hit the blue subscribe button. Help us continue to build this pro-democracy channel. New order in my hands. I'm going to read it to you. First, I'm going to give you the background of it. How did we get here? We got here because Donald Trump, using his co-conspirators, the butler and the valet, or the butler, valet, and the maintenance worker, to do blocking and tackling for him in a case he's no longer in, the Mar-a-Lago espionage classified documents case, had them file 2 pieces of paper in the last 72 hours. An emergency motion with Judge Canon, because why not? And an emergency motion with the 11th Circuit Court of Appeals, where the case is currently sitting. Judge Canon, I think, violating all sorts of jurisprudential edicts and her own lack of jurisdiction, issued an initial order blocking the release of Volume 1 and Volume 2. Volume 1 doesn't even have anything to do with her case. It has to do with the D.C. election interference case in front of Judge Chutkan. And Volume 2, Mar-a-Lago, until she could get, I don't know, full briefing, until the 11th Circuit spoke. 11th Circuit did a weird thing. They denied the emergency motion in front of them, but they didn't automatically sort of slap back Judge Canon. They asked instead that the Department of Justice, who's taken over the case for the special counsel, file a notice of appeal. So now we're back with Judge Cannon's courtroom. Judge Cannon keeps it in place and asks the government to submit over the weekend an attestation, a under oath declaration that they have looked at all of the Volume 1 about the D.C. election interference case, and there's nothing in it substantively about the Mar-a-Lago case. And if that's the case, then she wants to know that. And they did that. I reported on it. They dutifully submitted we looked through it carefully. There's 2 passing references to Mar-a-Lago, not substantive in nature. We'll let you know what they are. And they provided it to the judge that she wanted and to the other side. But they said there's nothing else in there. And based on that, she just ruled, while it's still she still has to chastise the Department of Justice for no reason, as if they've done something wrong here. She just doesn't like that she constantly gets wrapped on the knuckles and taught that she doesn't know the law by the Department of Justice, because she doesn't. So she scrunches up her nose and she has a jaundiced view of the Department of Justice, and she constantly reprimands them, even though they haven't done anything wrong. So here's what she said. She said, let me read it to you. Upon review of the emergency motion, that was by the butler and the maintenance worker, it is ordered and adjudged as follows. The emergency motion by them is denied. As to Volume 1, because she's relying on the representations of the United States that, quote, believes that nothing in Volume 1 directly or indirectly refers, relies, or bears in any respect upon any evidence or argument relevant to any of the charges alleged against defendants Nauta and D. Oliveira in this case. And then she drops a footnote that says, footnote 3, almost like warns the Department of Justice, to the extent that counsel for the United States has any doubt about the representations made to this court regarding the absence of a connection between Volume 1 and in this case, tell me now, you're reminded of your duty of full candor. Look, they know they're officers of the court. I know I'm an officer of the court. They know they're members of the bar with ethical obligations of duty of candor to the tribunal. I know that. She doesn't have to remind them of that to act like some tough guy. I am 100% sure the Department of Justice did not lie to Judge Canon about what was in Volume 1 versus Volume 2. But she has to be this school marmy rapping the knuckles thing, which almost by implication suggests they did something wrong when they haven't. Now she says as to Volume 2, that's a whole horse of a different color. Here we go. Volume 2 let's have a briefing schedule and a hearing before the inauguration. She doesn't quite say it that way, but that's what she means. So like by tomorrow, the Department of Justice has to file their brief and then the reply brief by Wednesday, and Thursday they're going to have a hearing in lovely Fort Pierce, Florida at 2:00 in the afternoon before the inauguration as to whether she's going to continue to block Volume 2. Now, what does that mean, block Volume 2? The Department of Justice and Merrick Garland have already said they're not releasing Volume 2 to the American people, like at all, until the case against the other two, the maintenance worker and the valet, is over. Either over because the case is tried, it won't be, by the incoming new Attorney General for Donald Trump, Pam Bondi, or they're pardoned, more likely. But that's still going to leave for Pam Bondi to decide whether to release it in the public interest. Merrick Garland has said it belongs in the public because of the public interest, but he is lateraling it to them. They're never going to release this report. This is like when Mueller left it to Bill Barr, incoming Attorney General for Donald Trump, to make the decision whether to release his report in its entirety. Same thing. I can't believe he's doing it again, but he is. He did say, Merrick Garland said, by law, he's going to give the report, Volume 2, in camera, meaning like on a server where you can review it, but not an actual copy. He's going to give it to the ranking members of the Judiciary Committee for the House and the Senate, which is Dick Durbin and Jim Jordan and Jamie Raskin and the other guy, okay, Congress and Senate. And only if they sign a declaration that or an agreement that they're not going to release it to the American people unless and until the case is over against the two co-conspirators. She doesn't like that either. Oh, these so-called ranking members, like so-called ranking members. I mean, did she fall asleep during separation of powers and checks and balances? All right. The president may have Article 2 powers, but Congress has Article 1 powers. And if she wants to play rock, paper, scissors, her Article 3 Constitution judge powers versus their Article 1 powers, she's going to lose. Congress gave and reserved for themselves in setting up the special counsel law the right to obtain by a mandatory law the reports when the conclusion of the special counsel's work is done. Yeah. She never touched, interestingly enough, the issue of whether Jack Smith being found by her to be unconstitutional renders his reports unconstitutional, because that would be nonsense. But that's baked in there. So if I'm, and she's trying to block Congress's will about how the special counsel runs. If I'm like at least Jamie Raskin and Dick Durbin for the Democrats, I'd move to intervene in the case before Thursday. To file an amicus brief, at least, to argue to Judge Canon she's wrong on separation of powers and that they need to get Volume 2. In the meantime, there's new reporting that other groups like Attorney General Chris Mays of Arizona has demanded that the Attorney General turn over at least Volume 1 to her, and not only Volume 1, the case file, the complete case file, all the witness statements and all of that over to her so she can continue to prosecute 18 co-conspirators with Donald Trump in Arizona, including 11 fake electors, Meadows, Giuliani, Mike Roman, and the rest. See, this is getting hot and heavy now. Now, just because Judge Canon ordered it, if I'm Merrick Garland, I'd hurry up and get this thing released by 12:01 a.m. Tuesday morning, like quick. 11th Circuit's still sitting on a briefing schedule, an issue that they could take the whole case away from Judge Canon and say, look, we watched you in action with these competing emergency motions and briefing schedules. Forget it. You have no jurisdiction. We're going to take it. We're going to allow Volume 1 on our own initiative, and we're going to allow Volume 2 to go out as well. I'm sure Jack Smith's going to appeal this new order that she just raised up to the 11th Circuit also. But as of right now, Volume 1 is free to be released at 12:01 a.m. tonight. Let's do it. Let's do it for democracy. Let's do it, Merrick Garland. Here we go. And I'll come back and report on it. As soon as I get my hot little hands on 1,000 pages and I can digest it, I'll be back here on Legal AF, I assure you, telling you what's in Volume 1. So in the meantime, do me a favor. We already hit, it's not even a favor, it's just helping us together grow this network and this channel. Hit the subscribe button. It does help. It is, we're kind of growing this channel, this pro-democracy channel with the Midas Touch Network with our bare hands. We really are. And then we're at 402,000 already. and we're only 4 months old, a couple days short of 4 months old. Our goal is 500,000 in our first 6 months. I think we'll get there, but only with your help. So until my next reporting, I'm Michael Popok. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories, the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.